We got a new ruling out of the D.C. Court of Appeals about the criminal contempt proceeding that has already been commenced by Chief Judge Boesberg of the D.C. District Court. He's ready to make a referral to the prosecutors of the Trump administration and wants by Wednesday either to have the Trump administration return 2 planes load of people from El Salvador who were sent there against his orders, or he wants names. He's taking names and he's kicking butt. He wants the names of the people that violated his order. As expected, the Trump administration ran to the D.C. Circuit Court, and they got, as I tried to manage expectations, a Trump-favorable 3-judge panel. And I'm going to tell you what the ruling means, what it means for the criminal contempt proceeding, for the finding by the judge of probable cause that the Trump administration committed criminal contempt, and what will happen at the United States Supreme Court and when. I cover it all right here on Legal AF. Look, while we're here, hit the button, subscribe. You're going to want to know about this information in real time when it happens. And where else to do it than here? Subscribe, get reminders every time we drop a video, which is 8 to 10 times a day right here at the intersection of law and politics. Subscribe. Okay, done with that little self-promotion. Let's go into the order. Now, when the 3-judge panel got assigned, which is how all appellate decisions get made by a 3-judge randomly assigned panel. There's about 20 judges or so in the D.C. District Court of Appeals. And the 3 judges that were assigned here were Judge Pollard, very, very good judge. He was an Obama appointee. Judge Katsas, Trump appointee. Judge Rayo, Trump appointee. So cherry, orange. 2 Trumpers, 1 Obama. I said I didn't like this panel. And the issue for the panel for now is whether the judge was right in issuing his order a few days ago that I reported on, which was the order, the memorandum of opinion finding it was more likely than not on a standard of probable cause for a referral to a criminal prosecutor in the executive branch, the Department of Justice and the Trump administration for violating Judge Boesberg's order a month ago to ground those planes, return those planes, and the judge heard enough evidence for him to establish in his own mind that the Trump administration, knowing about his order, still let 2 planes go. The Trump administration taunting and not complying with the rule of law. We just saw the official White House social media account yesterday not only taunt Senator Van Hollen by updating and redlining a New York Times article in a kind of a snarky, sophomoric 7th grade way, but they also are taunting the United States Supreme Court and us in the rule of law. Let me repeat, this is not about a guy named Armando Abrego Garcia or Kilmer Armando Abrego Garcia. This is about our rule of law and our Constitution, and Donald Trump using the Constitution like a doormat. No, worse than a doormat. Doormats get better respect than the way Donald Trump is wiping his backside with the Constitution. That's what this case is about. So whether I tell you the plaintiff's names are JGG or Armando Abrego or some future plaintiff, it doesn't matter. It's about the principles that are behind this and the attempt to try to stop an out of control, rogue, lawless presidential executive branch. That's what this is about. So when they took the appeal, the Trump administration ran to the D.C. Court of Appeals. They must have been rubbing their hands in glee when they got Katsas and Rayo assigned to the 3-judge panel. And as I said, it was going to be a heavy lift for Judge Pollard to pull Rayo probably. I think Katsas was a foregone conclusion over to her side in order to affirm what Boesberg has done. Now, they've only issued an administrative stay. When I say only. And we've seen a lot of administrative stays in the last 24 hours. The United States Supreme Court late last night on Saturday night, and I got another hot take up about this today, right here on Legal AF, they issued an administrative stay to give the government time to answer an emergency application to stop all Venezuelans who are about imminently to be deported and removed without any due process up in the Northern District of Texas, including a place called Blue Bonnet. Sounds idyllic, but I don't think it is for these particular gentlemen. And so the Supreme Court, 7-2, it looks like, said, yeah, no notice, or the notice was in English, not Spanish, and no time for writ of habeas corpus petitions to be filed. So no real due process under the Fifth Amendment. Why don't we stop all all people from being deported up in the Northern District of Texas under the Alien Enemies Act until we get our mind around it. You, government, you file a brief. We'll take a look at the briefs. We'll get back to you next week. Nobody leaves the country in the meantime. That was Saturday night. Now we've got another administrative stay issued by 2 out of the 3 judges, and that's all you need. You just need to count to 2. And the 2 judges, Katsas and Rayo, issued an order that said we're going to stay the process that Judge Boesberg put in place, because he has a very defined set of milestones and a process related to this contempt procedure. He found probable cause for criminal contempt, but when you get to criminal contempt, that has to be investigated and prosecuted by the executive branch. Asterisk, if the executive branch won't do it, and Pam Bondi's not going to do it for Trump, then the judge is empowered under a line of Supreme Court cases to appoint his own private attorney to be the special prosecutor. Cosmic justice. Attention, Jack Smith, put up the bat signal. You would be great for the job. That's that. He also set deadlines. A week from Wednesday, 2 things have to happen. One of 2 things have to happen. Either the Trump administration brings the planes back. Leave in comments the odds of that happening, especially given their position on Mr. Abrego Garcia. 0. So the Trump administration is not going to do that. So they won't purge the finding of contempt. Then they have to turn over the names because the judge hasn't been able through the administrative evidentiary process so far to figure out who violated. He wants to know who in the Trump administration, the Department of Justice, knew about the order to ground those 2 planes and who sent them flying and wheels up regardless. Names. We have a name for that in contempt world. It's called contemnors. Who are the contemnors? The ones that committed contempt. I want names on Wednesday. So that's now been stopped, that process. For now. That's the only thing that was the only thing going in the process. Because if the Trump administration didn't purge by Wednesday and bring the planes back, he was going to make a referral. And if the executive branch's Department of Justice wasn't going to accept it, he was going to appoint a private prosecutor. You see the constitutional collision that we are on right now. This is a war that Trump is on with the Constitution. It's a war, and we're the foot soldiers to protect it here on Legal AF. So here's the order. It's not going to give you any great comfort or satiate your thirst here, but here's the order. It's a paragraph or 2 paragraphs. It is issued by effectively Katsas and Rayo. It says, upon consideration of the emergency motion for a stay pending appeal, or in the alternative, a writ of mandamus, it is ordered on the court's own motion that the district court's contempt-related order entered on April 16th be administratively stayed pending further order of the court. That's the lowest stay in the book in the food chain. The next up is a temporary stay, and then a permanent stay until the end of the case. The purpose of this administrative stay is to give the court, meaning the 3-judge panel of the D.C. Court of Appeals, sufficient opportunity to consider the emergency motion for a stay pending appeal. That's the Trump side, or a writ of mandamus, and should not be construed in any way as a ruling on the merits. Well, that's true, and it's nice that they put that in there. It doesn't mean they made their decision. It means they don't want the process and the wheel to continue to turn while they're trying to get their handle and their mind around it. Further ordered that the appellees file a response to the emergency motion, meaning the good side of the case has to file their response by Wednesday. So same day the judge was using, Judge Boesberg was using, is now the new date for the response. And any reply has to come in on Friday. Once all those papers are in next week, then the appellate court will make their decision about the stay on a moving forward basis. Now, Pollard, in a footnote, wrote, Judge Pollard would not administratively stay the challenged order, meaning she would allow Boesberg to continue to turn the wheel and turn the screws against the Trump administration and let those Wednesday deadlines of purge or give me the names to stand. In the absence of an appealable order, she's saying there's no jurisdiction of the appellate court at this moment or any clear and undisputable right to relief that would support mandamus. There's no ground for administrative stay. I agree with Judge Pollard. Why are they issuing? First of all, they say it's on their own motion, their own initiative. Nobody asked for the stay. That's one. Two, it's coming off of a finding of contempt. That's not appealable as of right now. that there's still a process that has to conclude before the appeal is ripe. And that's what Judge Pillard is saying. Why are we here now? Why are we issuing the stay? Let Boesberg do his day job and run this case. We just saw, just to compare it, of how a circuit appellate court should operate. We just saw the Fourth Circuit Court of Appeals a day before yesterday support Judge Zinnes in Maryland and issue a scathing rebuke of the Trump administration in their, what looks to be their contempt of not facilitating the release of Armando Abrego Garcia from that jail in El Salvador and taunting the courts along the way. And so they supported Judge Zinnes, kicked it back to her to finish her process, including the discovery that she's ordered, depositions and sworn statements under oath. That's the way a Fourth Circuit 3-0. That's the way a Circuit Court of Appeals should operate. But when you got two Trumpers, Rayo and Katsas, you get this, mishigas. That's a legal term. You can look it up. As I said before, hit the subscribe button and hit the reminders. Once you subscribe, you'll get reminders for every time there's a video up. And these stories and this analysis is moving so quickly, almost at the speed of light. It's at least the speed of justice. Come here, Legal AF. This is where I curate all my work. I got about a dozen contributors. Shan Wu and Court Accountability Action and Dina Dahl and Melba Pearson and Dave Arenberg and the rest all here with me contributing every hour at the intersection of law and politics. This is important. We are the foot soldiers to protect democracy and the Constitution. I can't do it without you. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.